Let me begin by saying that the lesson of inevitability of democratic values within the legal order is not lost on any serious legal practitioner or even casual observer of goings-on in society and indeed the human destiny. Of the multifarious problems afflicting the country currently, hardly is anything more benumbing than the crises and contradictions inherent in our practice of democracy vis-à-vis the legal order. The situation would have been laughable if it was not so tragic. That a country so blessed with human talents and incredible natural resources has continued to work on its head is totally stupefying and inexplicable. However, it is appertinent to interrogate the historical antecedents of Nigeria in order to lay bare the characteristics of the contemporary legal order and difficulty to grapple with the desiderata of modernity and progress. I want to interrogate the precursors of the Nigerian state. Nigeria owes its creation to the antics of British imperialism. What is important to bear in mind is that when the British arrived in these shores, they carried along in their knapsacks English law and instrumentalities of conquest and subjugation of the restless natives. I use that phrase advisedly. I had a teacher in high school, an American, who whenever we were making some noise in his class, he would say, "The natives are restless." He didn't hit us then. We were teenagers in Christ School. But later, some of us braved on to take him on, to tell him he has no lessons to teach us in terms of decorum and good behavior. Now, Nigeria being one of the last territories to be colonized by the perfidious Albion, was subjected to the most distasteful aspects of race supremacist ideology, of disdain and disrespect for the traditions and mores of the indigenous population. This attitude had been practiced and perfected by the British in relation to the native peoples of America and Canada, Australia and New Zealand, India, etc. This superiority complex among the English was so deeply ingrained in their psyche, as the writings of Shakespeare reveal, Tempest and Othello being notable examples. I must note that as recently as 1857, the US Supreme Court, in the notorious Dred Scott case, still had the temerity to declare that the black man had no rights, that the whites needed respect, more so that he was only 4 feet of a man. Wherever the English went, he could relish in the thought, as Lord Palmerston had intoned, that the long arm of the English law would always protect him. Indeed, they refused to subject themselves to the jurisdiction of the native courts, which were thought to be infra dignitatem to English law, which they had transported to far-flung colonial territories as instruments of colonial hegemony and control. In Nigeria, as elsewhere, they had created their own special courts. You remember the courts of equity, which had jurisdiction over British people here And we had the colony of Lagos separated and made distinct from the rest of what they call the protectorate. This English court refused adamantly to apply the native laws and customs, that's the customs and traditions of our people, for they considered them, quote, repugnant to natural law, equity, and good conscience, a code phrase for English law. It took the genius and courage of judges such as J.I.C. Taylor and other like-minded jurists to win themselves off slavish adherence to English law and practice by striking blows for authenticity and independence of the Nigerian legal order, be it in relation to the rights of children born out of wedlock or the recognition of polygamy and the right to inherit as guaranteed under native law and custom. I recall her, excuse me, I have a whiff of influenza. I recall here the case of Inria Dadevo, Dawudu and Damole, and such like cases that we used to regale ourselves with in my classes on the Nigerian legal system. G.I.C. Taylor, as I remember him in his jockey cap, driving the sports car, and leaving the audience in a cloud of dust. We used to hail him then, J.I.C., and he would just speed away in Ikeja, where I grew up. Now, by the time Nigeria became politically independent, it had become cognizable to enlightened legal opinion that the repugnancy doctrine advocated by the British was indeed repugnant to our sense of values, propriety, and cultural wholesomeness. I come to the sub-theme, Democracy Nigeria Style. It is no exaggeration to aver that in Nigeria, democracy is still very much a work in progress. Having endured nearly 400 years of the slave trade and 100 years of British colonial exploitation and oppression, the Nigerian people had not been properly sensitized into the norms and practices of democratic governance. However, this is not totally unexpected of a people reared in unquestioning obedience to the whims and caprices of the traditional rulers, unelected elders, and on democratic belief systems stamped on the consciousness of the people after centuries of social conditioning and cultural manipulation. Nevertheless, needless to say, the first few years of the practice of majoritarian democracy in Nigeria were marred by different military junta, which had hijacked political power and held the country hostage for decades. Since militarism and democracy are odd bedfellows, it was hardly surprising that the Nigerian militariat succeeded in arresting the country's progress towards democracy and sought to entrench on democratic elements within Nigeria's political firmament. The most galling bequest of the military dictators was Decree number 24 of 1999, which it sought to pass off as the constitution of the country after its departure from the country's political stage. Although many people in Nigeria have forgotten the fact that we have a military decree masquerading as the Constitution of Nigeria, I am surprised that lawyers with relish will recite various sections of that particular odious instrument as part of the founding laws for the Nigerian state. Regrettably, rather than jettisoning that evil and unbecoming instrument, the incoming civilian rulers continue to live the lie that Nigeria was operating under an autochthonous fundamental law with fraudulent claims to the effect that it originated and had the consent of the people. The ringing condemnation by the patriots that the 1999 Constitution had lied against itself is not one to be forgotten in a hurry. God bless the patriots for lifting the veil of the instrument of military diktat. Nigeria bought for themselves a pig in poke, and for as long as we refuse to consign the despicable instrument into limbo, for that long will the legitimacy of the country's highest law be a crude and rude joke and an unacceptable assault on international best practices. Nevertheless, the lack of a universally agreed definition of democracy may avail our unrepentant defenders of the status quo in justifying the 1999 Constitution. Yet, truth be told, the illegitimacy of the Constitution puts a big question mark on nearly everything that has happened in this country since the people in Agbada replaced those wearing starched khaki uniforms. To borrow the words of Mr. Justice Jackson of the U.S. Supreme Court when he was describing pornography, although we might be unable to define democracy, we all know it when we see it. Accordingly, the essential ingredients of democracy, in my view, will include supremacy of the law, separation of powers, checks and balances, sanctity of the ballot box, presumption of innocence, freedom of expression, due process of law, independence of the judiciary, etc. In other words, democracy presupposes the final elements of Western liberal democracy. So can we really be said to be practicing democracy? Many have averred that what we actually have is a civilian dispensation, while democracy will seem to be a never-never land. Except and only to the extent that we cannot practice democracy without Democrats, Nigeria still has a very long way to go in order to arrive at the El Dorado of democracy. And we should quit the pretense that we are working under a democratic dispensation. Nigeria is not a democracy. It's a civilian replacement of military dictatorship. I now come to the epicenter of my presentation, the nature of the Nigerian legal order. Undoubtedly, Nigerian law and legal order are yet to shed their British complexion. As I was wisecracking with a member of the audience, the Nigerian lawyers especially have refused to put on the toga of legitimacy. They still behave, to borrow Ayodele's colorful expression, as Afro-Saxons. We know of the Anglo-Saxons, but Professor Ayodele called us the Afro-Saxons, neither British nor Nigerian. A funny hybrid. And when you look at the lawyer in the white wigs, black gowns, quaint mannerisms, strange forms of address, and all in a bid to retain the alien character of the appearance of lawyers of a bygone colonial era. In fact, when you see how even lawyers, some lawyers, not every lawyer, treats the wigs they wear rub the sweat off their brows and becomes, in fact, it becomes like a caricature of English lawyers. We really should feel sorry for the state of affairs of the legal order. Unlike some erstwhile colonial territories, such as the United States and Canada, where I had studied, the lawyers don't put on wigs, except when they are appearing at the Supreme Court. Lawyers in Canada wear black suits at the High Courts. Only the judge wears a barrister's wig. But I recall the experience of the late Jaja Nwachukwu, a distinguished orator from Dublin, who went to court wearing Igbo traditional dress. And the judge said, "Who is that sitting naked at the bar?" And Jaja Nwachukwu, of course, gave a good riposte. Said, "I'm dressed in the attire of my people." And the judge said, "It's not the recognized attire of the bar." Although he kept his stand, he sat at the bar because Jaja Nwachukwu was a lawyer. But he had the guts to wear the traditional Igbo dress to court and sat at the bar, which was considered a little bit odd, if not unbecoming. So countries like the first colony of Britain, that's the United States of America, and Canada, they've thought it fit to domesticate, as we say here, the legal profession by allowing novelty and reforms into their legal system. Unlike Nigeria, which has stubbornly refused to alter the modalities of both its law and practice. Yet the efficacy of a legal order stems very much from the extent to which it has captured and reflects the mores, values, and idiosyncrasy of its addressees. So much we have learned from advocates of the historical school of jurisprudence, and lately from Professor Thomas Friedman's concept of legal culture. I don't know how many people know of Thomas Friedman, who coined the notion of legal culture at the University of California. But maybe I should come to more familiar names. As underscored by Omoni Adewoye, Nigeria's leading legal historian, the imposed English or British colonial law bore all the imprint of alien domination and oppression. I'm borrowing from his doctoral thesis, which he presented to Columbia Law School in 1968. It's already published. So you look at the Nigerian legal order, it reminds you every day of the overarching posture of the so-called departed British overlord. It is for this reason that any discussion of the legal order must begin with a recognition of its colonial heritage and continued dependency on an alien power. Whether we speak of the legal system or legal order, we must realize that legalism, bereft of a nexus with the thought processes and attitudinal chemistry of the people, is of little relevance in coming to grips with the existential reality of a peripheral, dependent capitalist enclave such as ours. Somebody was poking fun at me when my citation was read. I studied law in Kyiv. Kyiv has become very well known now, and I bring greetings from the valiant Ukrainians who are fighting for their nation against Russian conquistadores. If indeed we go by the dictum of a government of laws and not one of men, as propounded by Chief Justice Marshall in Marbury and Madison, 1803, it will be straining logic too far to aver that Nigeria's legal order was indeed one founded on law and due process. Well, we are all lawyers. By the way, I'm a member of the Nigerian Bar. I had to borrow my sister's wig for my call to bar because I was so much against. And I remember Bola Ajibola on the high table at the law school saying, finally we got you. And I said, you've not got me. Up till now, I don't have either wig or gown. I used to pay my practicing fees until I retired. But since I don't go to court, I only consult, I've been defaulting on practicing fees. In fact, I was amused when the Lagos NBA called me Senior Advocate of Nigeria. They are not the only people to so call me. Iksan, also in their letter of invitation for my keynote address, called me San. Now, I'm not a San, but I've taught more than 70 Sans. So for me, after a professorship, everything becomes second best. In a situation of an illegitimate constitution, rancorous lawmaking, conflicting judicial orders, widespread disrespect for law and order, rising incidents of self-help, inability or refusal by the law enforcement agencies to perform their duties, and lack of trust and confidence by sections of the population in the state apparatus, it becomes highly problematic to envisage fidelity to law as an instrument of peace, order, and good government. One of our professors in Osgood, I was the late P.W. Hogg. He was an expert in constitutional law. And Canadian students used to joke and say, Hogg on POG. Hogg on peace, order, and good government, Canadian students abbreviate to POG. So it's Hogg, so they play on the word, Hogg on POG. Now, do we have peace, order, and good governance in Nigeria? I'm afraid not. But then we'll come to that soon. Now, it will simply be futile to contemplate the interrelationship of democracy and legal order, more so in a setting as fractious as Nigeria. The beginning of wisdom about contemporary Nigeria is that we are not yet a democracy, but merely a civilian arrangement. Accordingly, we need to embark on a transition from civil rule to a full-fledged democratic society in order to take full advantage of government of the people, by the people, and for the people. It is only by so doing that we can conceive an effective role for the legal order. To the extent that a legal order presupposes concomitance of democracy, to that extent will it be illusory to attempt to move Nigeria to another level through the instrumentality of the legal order. The coterminous nature of both democracy and the legal order is such that one cannot be pursued without the other. Legalism, unaccompanied by the benefits and allure of democratic values, is apt to result into outright fascism and blind adherence to the wiles of dictators and undemocratic forces. Therefore, a way has to be found to convince Nigerians on the desideratum of democracy as an integral part of the quest for an effective legal order. Pursuant to this, lawyers must be ready, willing, and able to be at the vanguard of the struggle for a better society. I'm not saying anything new here. Sapara Williams had said that way back in the 19th century. We should always remember, though, that V.I. Lenin, Fidel Castro, and Nelson Mandela were lawyers who stood on the barricade of the liberation struggle of their people. Our lawyers should therefore make a conscious choice to depart from self-seeking, self-serving, and self-considered motives in favor of ideals that will ensure life more abundant for the preponderant majority of our people. I know we have produced lawyers like the man we used to call Chairman Mao. I'm talking of Alao Akabasharun as president of the bar. And of course, the human rights crusaders like Femi Falana. I don't know if I can talk of Festus Keyamo as a civil rights crusader, because a friend in government is a friend lost. So if you want to be relevant to the people, you must strike a blow for the rights of the majority of our people. Many of our people still consider lawyers as liars. They believe that we don't represent their interests. So this is a loud call to the audience to make sure that the liberation of the people should be the touchstone of their legal practice. We have valiant Nigerian lawyers who have continued to answer the call of service to the interests of the majority of our people. Only thus can the profession attract greater understanding, relevance, and empathy among compatriots. The legal profession is today at a crossroads. With a multiplicity of problems afflicting law and the legal order, lawyers must rise up to the occasion by bringing to bear their special and unique knowledge of the workings of the legal system on ways and means of restoring hope, trust, and confidence among the people generally. Since popular acceptability appears to be the touchstone of democracy and good governance, no effort should be spared toward being harnessed in steering the legal order along the path of consolidating democratic values. Otherwise, yearning for a better society might end up being really little more than a pie in the sky. Concluding remarks. We are living in a world earnestly yearning for a better society. How this is to be achieved presents some difficulty. To many, democracy presents a most viable mechanism for attaining this objective. The situation in Nigeria is complicated somewhat by the deformed state of its democracy, as well as the overarching colonial coloration of its legal order. The task of shedding its colonial heritage is no less daunting than that of the legal system as focus for widening the democratic impetus in Nigeria's trajectory to a higher level of social organization. Since democracy is irretrievably intertwined with a functioning legal order, it stands to reason that creating a viable society is a laudable goal worth pursuing. It remains for me to express sincere appreciation to the Lagos branch of the NBA for enabling me to share with you my thoughts on democracy and the legal order, and to wish you all a successful annual legal week. I thank you very much for your attention.